Good afternoon, everyone, and welcome to Manitoba's second event for Access to Justice Week in 2022. My name is Natasha Brown, and I'm the Access to Justice Coordinator here in Manitoba. Today's event, People-Centered Data Collection, is hosted by the Law Society of Manitoba and will focus on some recent data collection projects nationally and within Manitoba. I'd like to start today's session with a treaty acknowledgement. Between 1871 and 1875, treaty commissioners, acting on behalf of the Crown, signed treaties number 1 through 5 with First Nations leaders. The treaties included agreements respecting the use of land we call Manitoba. This land has been the traditional territory of the Cree, Dakota, Dene, Ojibwe, and Ojibwe nations for millennia before the signing of the treaties. We would like to acknowledge that today's webinar hosts are situated on Treaty 1 territory, the traditional lands of the Anishinaabe, Cree, and Dakota peoples, and the homeland of the Métis Nation. We are pleased to welcome presenters and participants from locations in different treaty territories across Canada. We acknowledge with respect and gratitude the many First Nations, Inuit, and Métis people whose footsteps have marked this land for centuries. As a bit of housekeeping, we'd like to ask that you post any questions in the Q&A box, and please keep the chat box for tech-related questions or concerns only. There'll be time for questions at the end of the presentation. Some of today's slides will be provided to attendees via email later today. Because some of the data being presented today is only in its preliminary stages, not all of the material being presented will be included in the email package. Today's panel will be moderated by Allison Fenske. Allison is a lawyer with the Public Interest Law Center here in Winnipeg, where her work involves navigating legal issues through a social inclusion lens with a particular focus on people living in vulnerable or marginalized communities. In terms of data collection, the Public Interest Law Center recently completed a public engagement report to maximize their ability to fight for systemic transformation. PILC hosted webinars, one-on-one meetings with nonprofit organizations, grassroots groups, academics, and First Nations. This report is not yet available online, but you can contact Allison if you would like a copy. Allison also teaches gender and the law at the University of Manitoba and is a presiding member of the Cooperative Housing Appeal Tribunal. She's interested in access to justice issues and was the co-author of Justice Starts Here, the 2017 report on access to justice and the potential for a one-stop shop approach in Manitoba, published by the Canadian Centre for Policy Alternatives. In this report, Allison recommended better data collection on access to justice issues, so it's fitting that today Allison moderates today's panel. And with that, Allison, I'll turn it over to you.
Thanks so much, Natasha, and thank you everyone for attending. I'm going to briefly introduce our panelists and then we'll get right into things. First, Susan McDonald. Susan McDonald is a lawyer and holds a PhD in education from the University of Toronto. She's been with the Department of Justice Canada since 2001 and is currently the principal researcher with the Research and Statistics Division. In this role, she manages a team of researchers and is responsible for research on access to justice, victims of crime, hate crimes, gender, and other files. Thank you for joining us, Susan. Amy Richmond is a senior consultant and former partner at Prairie Research Associates, an independent research firm offering services in the area of program evaluation, market research, performance measurement, and general social science research. Prior to joining PRA, Amy was a lawyer and brings her combined legal and social science expertise to managing justice projects in civil and criminal law. We're also joined by Gerard Kennedy. Gerard is an assistant professor in the Faculty of Law at the University of Manitoba, where he teaches, researches, and publishes in the areas of civil procedure, administrative law, and constitutional law. He holds a PhD from Osgoode Hall Law School, an LLM from Harvard Law School, and a JD from Queen's University. Prior to entering full-time academia, Gerard was a civil litigator in private practice in Toronto. Heather Fast is the part-time policy advocacy director of the Manitoba Eco Network, a nonprofit environmental organization in Winnipeg. She's a PhD candidate at the University of Manitoba's Natural Resources Institute, studying ways to improve public access to environmental justice. She's also currently teaching environmental law at the University of Manitoba in the Faculty of Law. Before she returned to grad school, Heather practiced law in Manitoba, receiving her call to the bar in 2014. Sarah McCoubrey is the founder of Calibrate, a consultancy where she works with small and large organizations to tackle access to justice issues and challenges. Sarah has a JD in law from the University of Victoria and a Master's of Education from the Ontario Institute for Studies in Education. Sarah has practiced law focusing on education law, and that was followed by 10 years as the executive director of the Ontario Justice Education Network. So we have a really incredible, knowledgeable, and diverse panel here today. And so thank you all for joining us. With that, I'll invite Susan McDonald to present on Justice Canada's recent qualitative studies. Susan, over to you.
Welcome, everyone. Really pleased to see the numbers that we have here today, and I'm really excited to be speaking. You can see the title of this presentation. Let's go to the first slide, and I'll give you just a really quick outline of what I'm going to be speaking about. I'm going to start with a very quick background on research on access to justice, both system-focused and people-focused at the Department of Justice Canada. And then I'm going to quickly go through 3 examples of recent research that really point to people-focused data. The Measuring What Matters report, which I'll explain what it is, the Access to Justice Index for federal administrative bodies, and finally, the Canadian Legal Problems Survey and those qualitative studies on serious problems that Allison just mentioned. So let's go to the next slide, and we'll start with just access to justice research. So at the department, my group is in the policy sector, and we're a group of social scientists. We do empirical research primarily, and we have been working on access to justice issues since at least the 1980s. There was a really concentrated time from about 2000 to 2008 when we undertook a significant amount of research specifically on legal needs, both criminal and civil contexts. And that work was led by Ab Curry. And I did have the pleasure of working with Ab up until his retirement in 2014, but that we call that sort of the high point of research, people-focused research at the department in this area. I'm going to argue today that understanding access to justice really requires both an understanding from a system lens, so that we need system-focused indicators, and this would be what we would consider administrative data, also known as operational data, from those systems. So number of civil cases before the courts, or number of applications for legal aid. But we also really importantly need people-focused data, which is what is the topic of this panel today. And in those people-focused indicators, we get data that we refer to it as self-reported. So it's people actually talking about their experiences. This can be gathered through surveys, public opinion work, and at Statistics Canada, our national data collection agency, we have both kinds. We have administrative data, so courts data, but we also have self-reported data, such as we see in the Canadian Legal Problems Survey. I provide a link at the bottom of that slide, which and the slides will be circulated later, and that will take you to a page on the department's website with a list of access to justice reports. Next slide. So the very first example is what we call the Measuring What Matters report. And this is a report that was completed by a federal, provincial, territorial working group that was set up by deputy ministers responsible for justice and public safety. And the work began right at the outset of the pandemic. So July 2020, and we have measured the impact of the pandemic on access to justice and family and poverty law matters. In case anybody doesn't know the term poverty law, it is an umbrella term, and it refers to areas of law that have a disproportionate impact on those living in poverty. We chose to focus on sort of income supports or social assistance, as well as housing matters. What we ended up doing was, so we had two challenges, and this working group that did actually include a representative from Manitoba. And the two first challenge, which people might guess, is that the pandemic it had a clear start in March of 2020, but it actually hasn't really had a clear end. I know the ending has been announced in some jurisdictions, but in some ways we're still seeing impacts of that, dealing with backlogs and the things. So we didn't have a start and a finish. When we set up the working group to look at this, we thought we'd have a few months of the pandemic and we could easily go back and track the differences and the impacts on access to justice. And then just the second challenge was really the delay in system-focused data. So how long it takes for that data to come out. So at the bottom of this first slide here is a link to the report itself. The report was approved by deputies in December of 2021, by ministers responsible for justice in February, and sits now on a sort of FPT website. So next slide. So why is this important? We provided recommendations to deputies, and we argued that we should be elevating the importance of data and measurement in the areas of family and poverty law, as well as supporting transparency and accountability in regards to family and poverty law data. And then there were some actions. And really we were sort of sometimes we feel like we're fighting, there's a huge emphasis on criminal law and data around that, as there should be, but we really didn't want data and what happens in the civil system to go by the wayside. So next slide. So why are we calling this, or why is this approach of both system-focused and people-focused indicators really important? Well, we do need to know how the system is functioning. And so we selected, this is a list of the system-focused family law indicators that we selected. One of the primary reasons for selecting this short list was that we wanted the data to be national in scope, but also to be able to be gathered and presented at a jurisdictional level, so that we could tell the story of what's happening in Manitoba as well as at the national level, but also that data really it could be consistent and it would be accessible. Lots and lots of wish lists in terms of how does one measure access to data, and really great ideas out there, but we don't always have that data. So with these 5, actually I guess there's 6 in there because there are 2 different types of family justice services, we were actually able to collect those numbers for the years in question. Next slide. But we also really felt it important and stressed this, that people-focused data, those indicators were really essential to understanding. We know that what actually comes to the courts or to legal aid is only a tiny amount. It's like the tip of the iceberg in terms of the number of serious legal problems that are out there. And so we wanted to get self-reported data, the prevalence of family legal problems, or as we also call them, legal needs, as well as people's perspectives. So public confidence questions, and then how comfortable people were using technology online. So that sort of shift. And the first Those first, the prevalence of needs came from the Canadian Legal Problems Survey, and the rest of the data came from a public opinion survey called the National Justice Survey that the department puts out each year. And so we were able to ask before March 2020, after March 2020. And that was done in 2021 as well as 2022, and we'll be repeating it this January again. So that's a first example, and please, next slide. The second example is the Access to Justice Index for federal administrative bodies. I'm just going to use the word tribunals, and because federal administrative bodies is quite a mouthful. I talked about this in great detail yesterday during a panel with the Social Security Tribunal. We developed this Access to Justice Index a number of years ago, working with several federal tribunals. And we've since sort of marketed it kind of off the corner of our desk, saying, take the index challenge. The index challenge on the slide is also a link, so you can click on it and go to the department's webpage where you will be sent. It is not limited to federal. It was designed for federal bodies, but we've actually had a number of provincial bodies undertake the index and actually find it. They've used it and have found it very, very useful. So what it is a self-assessment tool. It's really a survey that tribunals themselves, whether that's members or staff or a combination, can complete with binary questions. So yes, no questions that are each weighted. And there's space for comments if you don't think it's totally relevant to your context. And what we do is we have developed sort of a model that we believe really reflects access to justice. You must remember that this was developed before the pandemic, when everything went online, or before sort of even online tribunals were a bit more common than they, more common today than they were. They also, so the self-assessment tool, sorry, I'm being distracted. I'm actually reading the questions as they're coming in, which I probably shouldn't do. But the self-assessment tool, you end up with a score. And what it does is it can help you as a tribunal, as an organization, really focus on, well, how could I start? How could I make my tribunal more accessible for clients? So why is this people focused? It's people focused because the weights that we attached to each of the questions, a 1, a 5, or a 10, the litigants, whatever term you might use in your particular context. So if, okay, so my video's off, that's fine. Thanks, Mike. And I think that what's really, really important here to remember is that the tribunal, we base these questions and these weights based on experience, based on client satisfaction surveys that a number of the federal tribunals themselves had received. So they were able to speak to, well, what's most important for those people who are using it. Here in these key messages, I want to note that the index is important because it can contribute to those conversations about how accessible your organization can be. Which responsibilities they should assume, and how they can discharge those responsibilities. It can also be used to support requests for increased resources, budgets, for example, or to put together new partnerships with governments, other public sector entities, or NGOs. And then it could also be helped for your organization to develop new standards. So that's a second example. We have got a couple more slides on this. So next slide. This is the framework that we've developed. We looked at a number of different models, including one we call the Sawson model over Justice Lawrence Sawson and his work on access to administrative justice. We also looked at a model coming out of the University of Tilburg in The Hague that looked at processes, costs, and outcomes. And the methodology for this, we based it on the National Access to Justice Index out of the US that was developed for state civil courts, all 50 states. And you can see here in this that we have 4 main categories, which are then broken down into subcategories. I should note in the development of this, we worked again with federal tribunals, but we also had 2 academic advisors, Professor Gerard Kennedy, who's at the University of Manitoba Law School, and then Professor Lawrence Sawson from Osgoode Hall. So next slide. And this last slide will actually show you what you would end up with. So you fill out the survey, it's online, or you can do it in a hard copy. You might need to consult with your HR department or your communications colleagues to answer, and you get a score for each category and then a total score. This fictitious tribunal has a score of 78, not bad, kind of a B+, but what's more important is that it will tell you where you can do better, and it will allow you to develop kind of that critical path for whether it's 1 year, 2 years, 3 years, for you to make your organization as accessible as possible. Okay, next slide. So the third and final example, and I think I'm doing okay for time, is the 2021 Canadian Legal Problems Survey and the complementary qualitative studies. Lots to say on this, but it's our most recent research, and it's a body of work of which we're particularly proud at the department. So the survey, which I'll call the CLPS, began in 2018, not the first of its kind. We've done several other cycles in Canada, 3 in the 2000s, and then 1 in 2013-14 was undertaken by the Canadian Forum on Civil Justice. But with delays, it ended up in the field right in the middle of COVID again, February to August 2021, a sample size of over 21,000, provinces only with an Indigenous oversample, but it was only people 18 and over who spoke English or French. And it was an online survey with, you could choose to do it by a telephone interview. We had a nice response rate of over 50% and a 2-step approach to capturing serious problems. So respondents were asked, had they experienced one of or more than one of these different serious problems in the 3 years preceding the survey. And if they answered yes, they were then asked, was the problem serious or not easy to fix? And then for those serious problems, people were then asked how they tried to resolve them, and then what were the impacts. This is sort of at its height, people-focused data. People are reporting on serious problems in their past 3 years, in their experiences. So next slide, and let's look really quickly at some of the results. 18% of people living in the provinces had experienced at least one serious problem in the 3 years prior to the survey. You can see a list there of the most commonly reported. These were sort of the top 5, and you can see consumer issues, harassment, discrimination, problems in the neighborhood. Again, remember, we're right in the middle of COVID, where many people are spending a lot of time at home. We also asked questions about COVID, and the most commonly reported problems were slightly different. So if your problem started during the time period of the pandemic, you were more likely to have employment or housing problems, along with the ones that were here. Next slide. So one of the key findings, though, was that Indigenous people report experiencing at least so a larger proportion of Indigenous people, 27%, reported experiencing at least one serious problem. And that was statistically significant when looking at the general population. The same was true for Black people, and a larger proportion of Black people were reporting a serious problem, 28%, again, statistically significant. Next slide. So good news is that 80% of Canadians reported taking some form of action. And you can see in this chart, searching the internet, contacting the other party, obtaining advice from friends or family are the top three. Contacting a legal professional is up there too, but it isn't in the top three. So that's actually a really interesting finding. And if you go to the next slide, we also asked people why they didn't contact a lawyer. And here are the top three reasons. Not what we might think, which is often that couldn't afford it. That comes in second most frequently selected reason. The top one is did not think it would be useful. So we also asked people who didn't do anything about it. So that small percentage, 1 in 10. And next slide. We can see the reasons why people chose not to take action. And the most, the response that was most often selected was that did not think anything could be done about it. So right there are some findings that for those providing legal assistance, whether it's through legal aid, a clinic, whether student clinic or even at the community level, really interesting to think about why people are not reaching out, So next slide. So impacts, we asked people about impacts, economic impacts or financial, as well as social, as well as health, both physical and mental health. And a significant number of those who had experienced a serious problem, almost 80% said that the problem contributed to some type of adverse health impact, with women significantly more likely than men to report each type of health impact. Extreme stress was the most commonly reported health impact by both men and women. And if any of you in the audience have ever had a serious problem, when you first hear about it, find out about it, are told about it, it really can create quite a bit of stress on top of whatever else is going on. So next slide. Here I'm going to shift. So I know I ran through that really, really quickly, but here I'm going to shift and just talk about the series of qualitative studies on serious legal problems. We knew from the outset that even though we had this great sample of over 21,000 people in the provinces, that there would still be minority populations where we could not speak to the findings just because the sample, the numbers of respondents would be too small. And so what we did was we did qualitative studies. And here you can see the actual minority population and the number of studies. These were done with community-based researchers across the country. And I'm going to very quickly summarize the findings for you. There's a link at the bottom of this slide for the published report. See here, and we have a specific web page on the department's website where the studies, we still have one to post, but so 10 out of the 11 studies are there in full, along with links to the Statistics Canada reports as well. So next slide, I'll go through this fairly quickly. The types of problems: housing, employment, family, social assistance, and then issues with the police and criminal issues. And these ran through these were the most common problems with the first three: housing, employment, and family. Most often we saw also perceived elements of discrimination and harassment on a number of different grounds. Social assistant issues were more prevalent for persons with disabilities, and issues with police and criminal sort of arrests, harassment, etc., were more prevalent for Black people and 2S LGBTQI plus people. Number of themes also emerged in addition to the types of problems. Obviously, COVID-19, since these studies were also done right in the middle of the pandemic, sort of through the end of 2020 and 2021. Access to justice, legal aid, where people were able to access it, as well as different ways of responding or not to the problem. Next slide. So just in terms of some key messages, everyone can read these themselves, but I think that one of the things, a couple things we wanted to identify was that, you know, these were studies about problems. So the issues, i.e. problems, were not unexpected, but even amongst the negative findings, there were some positive stories. And we use the same framework as in the quantitative, the CLPS. And this was a really useful approach to the qualitative studies because that framework mirrored the story we were telling from the actual data. Importantly, I think for us anyway, sort of within the department and the federal government in general, the qualitative studies gave us really valuable narratives, really rich detail, sort of that text, and that allowed us overall a better understanding around serious problems and how they're experienced by these minority populations. So just in my very last slide, if you can skip forward one more, why does this matter? So I've given 3 examples at the federal level of research that we've done in the past few years on people-focused research and the data that we've collected, both quantitative and qualitative. And we know here in our department that that data informs policy development and program funding. At least 7 of our funding programs at the department have improved access to justice and well-being for the long-term outcomes. But also we know that for people who are working on the front lines, this kind of continuous evaluation and monitoring can really provide insights for what's working, what's not. My next bullet says, let's think of more examples. I'm going to hand it over to our next panelist and stop talking because they have today. Thanks, everyone.
Thank you so much, Susan. Lots to think about. A few questions already coming in through the Q&A in the chat that we'll pick up in the discussion at the end of our presentations. And so we'll turn now to hearing from Amy with the Prairie Research Associates findings from the current survey of Manitobans regarding legal needs. Amy.
Hi, everyone. Thank you so much for joining us today. I'll just get my presentation on the screen. And hopefully everyone can see that now. I want to tell you a little bit. I'm going to be presenting the preliminary results of the survey of Manitobans. These are preliminary results, so I am just going to go through some high-level findings for you. But I first wanted to tell you a little bit about the context of the study. And hopefully you're seeing my slides flip through, so somebody let me know if that's not working correctly. But in terms of the context, the survey of Manitobans on civil and family law issues is one part of a larger research project that PRA is doing with the Manitoba Law Foundation. The project is to support the Manitoba Law Foundation's work in access to justice issues related to family and civil matters, including the development of performance metrics to measure the performance of the justice system and related programs and initiatives. So an earlier part of the project included an extensive literature review that was conducted by PRA The literature review provides background on family and civil law, legal needs and access to justice issues, and includes an inventory of Canadian legal needs surveys and access to justice metrics initiatives. The report was done in early 2020, and it can be found online on the Manitoba Law Foundation's website for anyone who might be interested in that report. For the survey of Manitobans, the Manitoba Law Foundation received permission from Justice Canada. Thank you very much, Susan, for working with us on this, to use the 2021 Canadian Legal Problems Survey questionnaire. Justice Canada, as Susan has given more detailed findings on what they found for that particular survey, but Justice Canada commissioned Statistics Canada for the CLPS, and Statistics Canada developed and extensively tested the survey questionnaire that was used for that survey. And that was the questionnaire that we used with just a few minor changes for the survey for Manitobans. And you can see on this slide that the survey covered a number of issues. We'll only touch on some of those issues today. I wanted to say just a few words on the methodology. And if it's quite different from what the federal government was able to do. And Susan, maybe when answering questions later, we can talk about those differences a bit more. PRA, similar to the Department of Justice, conducted a mixed mode survey, meaning that individuals were randomly, but in our particular way of doing it, it was a bit different. We randomly recruited individuals by telephone, and they were given the option of taking the survey by phone or online. Most of the individuals that were willing to take the survey opted for the phone survey. The survey was offered in English and French and was available for 12 weeks. And at the end of the 12 weeks, a total of 833 Manitobans took the survey. We oversampled in some key demographic groups, those who self-identify as Indigenous, as well as those living in northern Manitoba and rural southern Manitoba. The geographic areas were defined by using the first three characters in an individual's postal code to enable us to kind of slot them into the proper geographic area. With over 800 Manitobans participating, the error rate in this survey is plus or minus 3.5%, 19 times out of 20. And so the results will be representative of the population of Manitoba. They were weighted using the 2021 census by age, gender, and income. This is often done because individuals willing to answer surveys tend to be older, female, and of higher income. So we do the weighting to make the results more representative of the Manitoba population. But I did want to note that during the survey process, we did make substantial efforts to get respondents from those younger age groups in particular. So I just want to emphasize that the results today are preliminary and are just a small subset of the findings. You will note that Susan provided more findings from the national survey. We're just providing some some highlights really, because the analysis is still underway. And we will be analyzing the data for statistical differences among key groups, as you can see on this slide. In terms of who took the survey, this is unweighted data. This provides you with a profile of the respondents. And by unweighted data, I mean that the percentages that you see here are based on the actual number of respondents who took the survey. So you can see what I was talking about before. 60% were female, 72% are 45 and older, and 44% had a household income of $65,000 or more. So that's the reason why we weight the data then to bring it the results more in line with the population of Manitoba. Here as well, and these are the areas in which we also did the oversampling for the survey. You can see in the regions, you can see the effects of the oversampling. Winnipeg makes up 51% of survey respondents. It's a bit more than that when you're looking at the actual data of the population data for Manitoba itself. 14% of survey respondents were from the north, 14% were from what we're calling the rural south, which was southern Manitoba, not Winnipeg, and also removing the major centers like Steinbach, Portage la Prairie, Brandon, areas like that. And then the urban south would include those larger centers. And the reason that we split the geographic areas this way is we really are trying, when we do the analysis, to see if there are differences for the more rural and remote areas like the north and the rural south. And you can also see on this slide that 12% of the individuals that we surveyed identified as being Indigenous. So just to provide you with some high-level findings today. Survey respondents were asked a bank of questions listing potential disputes or problems. And based on those results, in the last 4 years, 44% of Manitobans had at least one dispute, and 45% of those Manitobans had more than one dispute. So 44% of Manitobans had any dispute at all, and then of those with at least one dispute, just under half had multiple disputes. As you can see on this slide, and I don't know if you can remember what Susan presented, but the disputes or problems most often experienced are similar, though the percentages are lower in Manitoba, but it's the same categories of issues by and large, which are problems in the neighborhood, poor, incorrect medical treatment, being discriminated against, or being harassed. I will take a moment to note another difference between the federal survey and our survey was the federal survey was asking people over the last 3 years. Our survey happened later because we didn't want to overlap with the federal survey at all. So our survey happened just recently closed. We were asking people about the past 4 years because we decided that we were going to expand the time frame because of the pandemic. We were just wanted to get more years pre-pandemic to try to mitigate the impacts of the pandemic on the answers to some of these questions if we could. So in terms of Manitobans who experienced at least one dispute or problem in the last 4 years, 62% of those people considered it to be serious and not easy to fix. So almost 2/3 of people experiencing a dispute or problem found it to be serious and not easy to fix. You can see on this slide the list of problems most likely to be considered serious by those experiencing them is quite different from the list of the problems most often experienced by Manitobans. Each of these issues were experienced by 5% or fewer of the people taking the survey, but a larger proportion of the people who experienced those problems considered them to be serious. So you can see here it's getting disability assistance. 86% of people who experienced that issue found it serious and hard to fix. Child custody, child protection, similar percentage. Money owed or money owed to them. 72% found that to be hard to fix, and civil court proceedings, 70% found that to be hard to fix. Just to give you like an example of how it's different, and I'm giving you the biggest difference from the previous slide, problems in the neighborhood, which was the #1 problem that people had experienced, only 43%, excuse me, considered that serious or hard to fix. And as Susan mentioned, the survey also asked people about whether the pandemic had made the problem worse or more difficult to resolve, and almost half felt that it had. Then one of the measures of access to justice is looking at what help was sought to resolve the issue and being able to take action to resolve their issue. So the survey asked Manitobans about what actions they took. And you can see on this slide that approximately 9 out of 10 Manitobans who had experienced a serious problem had taken some type of action to resolve it. Most commonly, it was more informal or self-help type actions, such as seeking advice from family or friends, or contacting the other party directly, or searching the internet. 1 in 5 contacted a lawyer, paralegal, or law student. And of those who contacted a lawyer, paralegal, or law student, I just wanted to add that most, about 2/3, contacted a private lawyer. And that was followed by legal aid, where about 1 in 5 reported that they had contacted legal aid. In terms of one of the ways that barriers to accessing justice is often measured, why people don't contact a lawyer or paralegal or law student, a legal professional, to receive help. Again, looking at that affordability issue. So here are the 3 most common reasons, and similar to the federal findings, cost was not one, it was the 3rd most common reason listed. About a quarter said that they didn't contact a lawyer or another legal professional because they couldn't afford to pay for legal help. But the more common reasons were that they didn't think it would be useful, or they preferred to resolve the matter on their own. In terms of another way of measuring a barrier to accessing justice is that notion of, did people understand the legal implications of their problem? Do they know where to get advice and information? You can see the results here, that just over half of Manitobans with a serious dispute or problem did not understand the possible legal implications or where to go for information or advice. And then looking at the impact of the most serious problem or dispute, there are a number of questions, and Susan provided more information on the federal survey, but there are a number of questions about the impact of the most serious dispute or problem on the respondents. So we've reported on one key question here, which was, which of the following did your most serious problem cause? Which of these impacts that are listed here? And you will see that approximately 3 out of 4 reported some impact, with most of the people reporting extreme stress, followed by mental health problems, physical health problems, and then social, family, or personal issues. So next steps for this study, as I've mentioned a few times throughout the presentation, the survey is still in its early stages of analysis. So we're going to continue working on the analysis, and we'll be providing a report to the Manitoba Law Foundation. The results will be made public by the Manitoba Law Foundation on its website sometime in 2023. So you can all look forward to seeing that if you want to check the website for those results. So that is my presentation. I guess I will turn it back to you, Allison.
Thanks, Amy. Thank you so much. Our next presenter is Gerard Kennedy, and Gerard is going to be speaking about preliminary data from a current survey of Manitoba legal service providers about perspectives on unmet legal needs. So a great compliment to what we've just heard from Amy.
Yeah, thank you very much for the introduction, Allison. It's a real pleasure and honor to be with you here today. Everyone can hear me and see the slides. Nothing but the slides? I'll take that as a good example. No one's objected to that. Okay, that's great. So as Allison alluded to, I have recently been collaborating with Natasha Brown of the Law Society of Manitoba in surveying the views of Manitoba legal service providers, in other words, lawyers and articling students, in terms of what they believe are the areas of greatest need vis-a-vis access to justice in this province right now. I will state at the outset that these are preliminary data, very preliminary. The survey only ended at the end of September, and we're still crunching the numbers and doing statistical analysis, but I want to show you some early stage results. The impetus of this is that there have been similar surveys conducted in other provinces, notably our neighbors, Ontario and Saskatchewan, in terms of what legal service providers believe are the major access to justice needs of clients in their provinces. And so we thought, well, probably it's a good idea to do the same in Manitoba, because we often talk about various interventions, but what do people actually think will be helpful? So in September, I believe we actually released the survey on September 1st and left it open until September 29th. We send out a survey conducted via SurveyMonkey to all licensed legal professionals in Manitoba. So again, lawyers and articling students. We received responses from 124 individuals, which isn't a great take-up rate, but it's not small either. We acknowledge there are limitations to this type of methodology in a couple of ways. First, the respondents are those who clearly felt disproportionately they have something to say. And it's not necessarily statistically representative. At the same time, we think that that can be just as much an advantage as a disadvantage, because those who disproportionately feel they have something to say may be those who most deal with the Manitobans in need of access to justice interventions. Those who are conducting tax transactions may be less so. We also are dealing with legal service providers as opposed to those who actually experience the justice system. And we've already heard a lot today, particularly in the last presentation, about the importance of placing those who actually experience the justice system at the heart of access to justice analysis. Having said that, we view this as complementary to the experiences of individuals. Moreover, individuals by their nature can speak to their experience, while legal service providers can have more of a systemic view, which insofar as we are seeking to have systemic interventions from a policy perspective, could be potentially helpful. So the first area we asked about is which area of law do we believe legal services are most in demand and not adequately offered? And I have up there all responses that had more than 10%. Why do they add up to more than 100? Because people were allowed to list up to 3 areas. But you see, overwhelmingly, family came out on top, with 46% of respondents indicating this is a top area where legal services are not adequately offered. In second place is a related field of child protection at 23%. This didn't surprise us, but perhaps the extent to which this is the case slightly surprised us. Family law is a classic example of where individuals do not have adequate access to legal aid, but the expense of incurring a lawyer can be absolutely prohibitive. And so it leads to real unmet legal needs. You also see criminal at 23%, which is interesting because we do have a legal aid certificate program there, though one wonders if it's sufficiently generous. Aboriginal Indigenous issues at 19%, residential tenancies, general civil litigation, immigration, given how few lawyers practice in the area, 14% of people saying immigration is not nothing. And lastly, government support. These are all areas where the survey respondents felt that there are unmet legal needs. Why is this the case was our immediate follow-up question. Here, respondents could indicate as much as they wished, and low profit was the #1 area. There just isn't enough of an ability for lawyers to make an economic go by offering services in these areas, followed by the fact that free or subsidized services such as legal aid aren't available. Interestingly, 40% of respondents also cited the complexity of the law and legal procedures, implying that people can't adequately do things on their own. Complexity of law has been discussed as a real access to justice impediment in the literature, and seeing this responded to quite this extent was somewhat surprising. Lack of capacity among service providers, lack of interest in providing services, interesting. Lack of collaboration between legal and non-legal service providers. 24% of people cited that. Given the extent to which family law in particular is tied to areas like social work and mediation, that's not surprising, but it's curious to see it, or interesting to see it so clearly backed up by the data. And lack of expertise. When we get to interventions, we'll come back to that. So what would help, essentially, was our next question. And again, the first two responses, the only two to receive more than 60%, the only two to receive more than 35%, both receive more than 60%, and increased availability or free and subsidized services in this area. Who wouldn't object to more money and expansion of legal aid, and additional resources dedicated to service provision. So even if you're not getting a lawyer, there is perhaps more legal aid clinics, there are more self-help going on. Both of those, more than 60% of respondents believe would be helpful interventions. More than a third of people posited allowing alternative legal service providers to provide some services with a limited scope. That's interesting. We'd have to have a discussion about how that would work, but you could see again in particular areas like, say, family law and child protection, having individuals with significant training but not a full legal education could help improve collaboration between legal and non-legal service providers, greater community outreach. There seems to be an absence of people, actually lawyers reaching out to those who most need their services, increased alternate billing arrangements, suggesting that sometimes the problem might not be the fees per se, but either the hourly model or the unpredictability, things get out of control. Providing greater training for non-legal service providers and CPD for lawyers. As noted, lack of knowledge was also cited as a reason for the delay. So we see that also backed up in terms of what would help. We also asked demographic questions about who is most in need of legal services. These are everything, all the demographics that received more than 15%. And somewhat not surprisingly, but I mean, sometimes you don't think about this these ways, low income earners at 58% was cited to be a group most in need of legal services and unable to afford them. Immigrants, newcomers, refugees also had a third. Those unfamiliar probably with Canada implicit in there. Indigenous peoples, 31% of people. Interesting, middle income earners, 28% of people suggested was a demographic in need of legal assistance and couldn't get it, implying that lawyers these days are the ability of the wealthy. Not only do low-income people manifestly unable to afford a lawyer, those with the middle income are the same problems. Persons with mental illness, 26%, unemployed or economically inactive persons, probably related to low income, homeless persons, 22%, and interesting, young adults of all the age demographics, even more than children, those who are young adults are considered to not be able to access legal services despite needing them. Why are these groups disproportionately need legal services? Was our next question. And the response that was most common, by more than double the next response, free or government subsidized services such as legal aid are not adequately available to provide supports to this group, implying that these people in these groups, such as low income, they need legal aid or government subsidized services, and they're simply not available. Lack of capacity among legal service providers was cited by 28% of the respondents. Lack of collaboration between legal and non-legal service providers was cited by over a quarter. A fifth of people cited lack of community outreach. Again, maybe we're fishing in the wrong pond. And lack of expertise among legal service providers to meet the group's needs. What should be done? We actually had quite a few responses that got more than 20%, which was somewhat interesting. Most of our responses did not get this breadth of response. But again, we see the first two with more than 60% each are additional funding for support networks and greater access to low cost or free full scope representation. Greater access to limited legal scope representation also came up at 46%. Community-based restorative justice approaches had a third of people responding, somewhat interesting. Greater access to legal information, implying self-help can help, not like be a silver bullet, but can help around the margins. Utilizing ADR. I know my colleague Jennifer Schultz has been through part of these last couple of days, not sure if she's online now, certainly has done a lot of work in this area. Greater collaboration with community service providers, again, implying that the legal profession isn't necessarily hunting in the right area. Greater community outreach. Legal services in remote areas were cited by 24%, and access to alternative legal service providers. Do we need to have a greater role for notaries or paralegals? Maybe. It's not something I've too strong an opinion on, but a substantial number of people have suggested as much. I also asked respondents to give, or Natasha and I did, qualitative answers. These are still very much being triaged, but an overwhelming thread running through them is a lack of government support for anywhere outside of criminal law, and sometimes not even in criminal law. That is something that needs to be thought about more methodically from the province. Perhaps not surprising in the abstract, but seeing it is particularly interesting. And that is basically the preliminary results that I can share right now. Maybe we'll have a discussion through questions later on, but I hope you found that somewhat interesting, and I'll turn it back over to Allison.
Thank you, Gerard. That's really interesting to hear. And we're going to jump to another preliminary results of ongoing research, and that's Heather Fast. Heather's going to be talking about the Manitoba Eco Network's Healthy Environment, Healthy Neighborhood project and the preliminary results from that study. Thanks, Heather.
Okay, hopefully everyone is seeing my screen properly. So hello, everyone. I'm very pleased to be here today and appreciate the opportunity to participate in this panel. So my name's Heather Fast, and today I'm here in my capacity as the Manitoba Eco Network's Policy Advocacy Director. The Manitoba Eco Network is a public interest environmental organization that seeks to promote and facilitate good environmental governance and the protection of Manitoba's environment for the benefit of future and current generations. A small research team from the Eco Network, led by my brilliant colleague Alexandra Caparelli, has been working on a community-led research project over the last year that I'm here to talk about today, called the Healthy Environment, Healthy Neighborhood Project. We've had many wonderful contributors to this project, which was funded by the Manitoba Research Alliance and the Manitoba Law Foundation. You can find them listed at the end of this presentation. We greatly appreciate all of their contributions. So in the Healthy Environment, Healthy Neighborhood project, we focused on gathering insights from residents of inner city and mature neighborhoods in Winnipeg who live or work near industrial sites and zones. A mix of different people live in these areas, although as you move towards the center of the city, there does tend to be a higher proportion of low-income individuals, Indigenous peoples, and people of color. But no matter where our participants lived, one commonality that we heard was concerns about a broad range of environmental health and health impacts, and the feeling that government did not care. We sought answers to a range of different questions focused on gaining insight into community concerns and identifying possible legal and policy solutions to improve citizen access to environmental justice in Manitoba. Although this is just a preliminary list, as you can see, our project participants identified a broad range of concerns that they linked to historic and ongoing industrial operations in their communities. This includes a range of different contamination, noise pollution, dangerous and scary situations resulting in explosions, metal shrapnel, and fires, a variety of concerns about health impacts, and an emphasis on mental health impacts. Many participants expressed a sense of futility. A lot of people were feeling like no matter what they did, government and industry just wasn't going to listen to their concerns. So overall, our participants have suggested that current policy and legal approaches need to be reevaluated and reformed to better address community needs. Now, before I dive into some more of the insights we've gained from our project participants, I want to talk a little bit about environmental justice. So I've been undertaking environmental justice research for the past 5 years, and like with many legal concepts, there's rarely agreement on what environmental justice actually means. So this term is often linked to the grassroots environmental justice movement in the United States, led by Benjamin Chavez in the 1980s, in the fight to protect African American communities from exposure to toxic waste. Environmental justice is also often linked to the concept of environmental racism and systemic racism more generally. In the majority of the access to justice studies undertaken in Canada over the past few decades, there's little to no mention of the environment or the legal services need to improve access to environmental justice. There has been some recent discourse within our profession on climate justice, most notably the CBA resolutions introduced at the 2020 and 2021 AGMs. And we've seen some local recognition of environmental justice needs by the Public Interest Law Center in their recently published report that we think everyone should go and check out. On the other hand, in an academic context, there's lots of discussion about environmental justice and a range of different recognized types and subcategories that fall under the environmental justice umbrella, such as climate justice, energy justice, and those other elements listed on the slide. We've even seen some recent legal developments in Canada that include direct recognition of environmental justice and environmental racism. For example, in legislation in the Northwest Territories and in Nova Scotia, and in private member bill C-226, the National Strategy Respecting Environmental Racism and the Environmental Justice Act, currently being considered in the House of Commons. So what does this mean for this project and people-focused data? Well, what we ended up doing with all of these wonderful insights on environmental justice was to take a broad approach to environmental justice in our Healthy Environment, Healthy Neighborhood project. So as a research lens, environmental justice to us is focused on equity, empowerment, and meaningful policy and legal change. Since our project participants had a range of different experiences, we didn't expect anyone to agree on how environmental justice was defined. It was about letting them tell us what they thought and seeking to include all participants. Thus, in terms of access to justice outcomes, we didn't ask participants to limit their solutions to a particular piece of legislation or legal process or even a specific jurisdiction. Instead, we have sought to find solutions that address all community concerns. So as a result of this broad approach, we found that instead of the more legal services focused suggestions that we were initially expecting from participants, we ended up learning that you actually need a lot more than just lawyers to fulfill an impacted community's access to justice needs. So one of the surprising things that we learned was that in order to improve access to environmental justice in Manitoba, there's a need to improve access to environmental and health data. When I was discussing this presentation with my colleague Alexandra, she was nervous about emphasizing the need for more data because the need to undertake further studies or develop some type of plan or strategy is often used by regulators to delay the implementation of legal and policy provisions that would otherwise create immediate change. However, it's important to recognize why our community participants so often emphasize the need for more data and understand that the utility of such data depends on how it's collected and how it's used. So one of the #1 reasons participants identified a need for more access to data was to better evidence the negative impacts they experience and hold government and industry accountable. Evidence. This is, of course, something that us lawyers understand well. And if you've ever looked into the requirements of successful toxic tort lawsuit, you'd understand that it's often extremely hard to evidence legal claims made in situations where toxic contamination and negative health impacts are experienced. More evidence is also viewed by our participants as a potential means of improving the enforcement of existing regulatory provisions. To ensure available information about industrial operations and negative impacts is considered credible and can be relied upon by community members, many participants also emphasize the need for more independent testing opportunities, ideally funded by government. Similarly, many participants felt transparency and legitimacy of data collection processes would also be improved if community members were given a direct role in the process. So how have all these wonderful insights from our participants helped us come up with legal and policy recommendations that will improve Manitobans' access to environmental justice? Well, first of all, we ended up considering a much broader range of legislation and policy and focusing on certain jurisdictions that we initially thought would not be as relevant. So for example, we've ended up doing a lot more engagement at the federal level, mostly in connection with Bill S5 and Bill C226 than we ever expected. And we've learned a lot of valuable things from this federal engagement. And second of all, we gained a better understanding of the other supports needed to assist with legal needs. So basically everything I've just been talking about in terms of data and independent testing. So although I can only share some preliminary thoughts at this time, as our final report is going to be published next month, our recommendations cover a variety of legal needs and solutions, ranging from better enforcement of existing provisions to reform of existing laws and policies, all the way to creation of new legislation, like an environmental Bill of Rights or anti-SLAPP legislation. And many of our recommendations focus on ways to create a more meaningful role for the public and public interest organizations in environmental governance processes. As I've already mentioned, we found that access to information is much more important in achieving the community's access to justice goals than many lawyers may think. So moving forward, we in the legal profession need to acknowledge the importance of knowing how to collect and use scientific and other expert evidence when dealing with environmental issues. One of the key lessons we've learned is that collaboration with experts in other fields can be an important way to help meet the legal and access to justice needs of community members. Overall, taking a community-based approach to the Healthy Environment, Healthy Neighborhood Project, and letting the community guide our understanding of their access to justice needs was a very incredibly valuable experience. Lawyers, of course, are definitely still needed, but we need to be prepared to assist our clients dealing with environmental issues in different ways than we may expect. It's possible that you might face a potential onslaught of technical and scientific information, but in many situations, community members are instead faced with a complete lack of available information to evidence community claims. So we need to be better prepared to deal with both situations. In my experience, you will never find a harder working group of clients and colleagues than people trying to protect their friends, family, and homes from negative environmental and health impacts. It should be a priority within the legal profession to learn from them how we can support their legal and data needs better and help impacted community members achieve their access to justice goals. Thank you very much.
Thank you, Heather. Lots to chew on. Our last presentation amongst the panelists before we move into our question and answer and discussion is from Sarah McCoubrey. Sarah is going to be speaking about some insights into what we can do with access to justice data and what some of our next steps are. So a great way to wrap up our panelists. Sarah, over to you.
Thank you very much, Allison. And it's been a delight not only to join you all, but to hear those really detailed descriptions of some of this data work in progress, those early findings. You know, we often don't get to see some of that the content as it's coming and being released. So that was a great conversation. I'm going to try to take us sort of a step out around what we might do with that, or how we might think differently about data in order to really take some of these little nuggets we're getting nationally, provincially, or in Heather's example, thematically, and take them into a new context. Just for a bit of context, I am retained as the strategic advisor to the Action Committee on Access to Justice. And I'm going to be speaking today about the use of data in that context, in the work that the Action Committee is doing, or how we could be actually coordinating better nationally to have that those macro, micro views that help us know what to do with the data. But I also work a lot with UN agencies and sort of other organizations working to advance A2J. And so some of this conversation actually comes from my thinking about the potential of data from those contexts, both what's happening in Canada and what could be happening based on those other models. First, just anticipating a question, what is the Action Committee? I'll share a website in the chat at the end. The Action Committee itself is a collaborative, volunteer-based network of people working across the country to advance access to justice. Its members are formal members who represent each province or national justice sector institutions, but we do have a organizational A to J newsletter, some ways of connecting and ways that everyone is invited to participate in. And I'm going to just share the link in the chat. If you're curious about finding more, please take a look and join us and engage in that way. I won't otherwise speak that much about the Action Committee itself. Turning instead to our conversation today, the Action Committee has been looking at access to justice metrics over the last 10 years and really trying to spur some national momentum and coordination of data collection. The Metrics Committee actually worked closely with Justice Canada to sort of make the case for and talk about some of the need for research that Susan talked about earlier. We also work within the international people-centered justice movement. And so I think this is where I'm going to try to take some of the specific projects we've just heard about and root them in that people-centered justice movement. People-centered justice as a movement is spearheaded by the Justice Action Coalition, and that's a group of UN agencies, academics, champions of access to justice, who are advocating for a shift from system-centered to people-centered. Now, this isn't just, as we often think when we first hear people-centered justice, oh, we need to learn what people think. It's actually a bigger shift than that. We're not just learning about it for our system-centered questions and curiosities. We're actually trying to shift our justice system delivery and therefore also our data understanding to really being people-centered. This is way too short a time to get into all the complexity of what that shift means, but I'll give you a couple of examples about why I think it's important. It means we might no longer think about the challenges people face based on substantive legal categories that lawyers and courts find really useful, but don't in fact reflect how people experience conflict. It might be useful to talk family law versus criminal law, or administrative versus processes that are happening in a more formal court. As useful when we think about lawyer specialization or how our court processes work. But the reality is, when people are experiencing intimate partner violence or discrimination or sexual harassment, they don't organize their experiences according to the part that's criminal and the part that's civil and the part that's administrative. They don't care that some actions are only relevant to one legal test or another. They also don't necessarily think about when their experience starts and ends. They're living that conflict, kind of overwhelmed by the uncertainty and the fear and the embarrassment, the trauma, the harm, all of those aspects of the events. Forcing all of these messy human emotions and experiences into our clean boxes is just one example of how we take a system-centered approach to our practices, our courts, our topics we study in law school, and maybe our eligibility for services that's more system-centered than people-centered. Now, I'm not proposing that we abandon all of those very useful categories to learning and delivering legal services, or that we create some melee of legal problems. But I do think that as we talk about data in the context of increasing access to justice, our starting point should be how people experience and understand the conflict in their lives. Not just in terms of asking the questions that we've heard about today, but when we look at the data and when we decide how to interpret that data, that we're also making that shift. I really liked Heather's observation just now about, what do people want us to do with what we are learning when we are learning asking these harder questions? Not just what do we want to do, having treated the people we survey as a source of data, and then how do we use it, but actually, what do they want us to do with that data? How do we be people-centered in that context? So when looking at data, I think this shift is a particularly interesting one. Are there new sources of data? Can we take the data we've heard about today and line it up next to the kinds of data that we get from the health sector, from the education sector? How do we understand the spectrum of experiences? Each of these kinds of shifts is how we start to make that people-centered approach. So with all of that as some background, I'm going to share 2 data projects that the Action Committee took on and where those might take us. The first one was to look at the amount of existing data that is shared publicly currently. It started in 2019, and then we updated it this past summer, and the Action Committee actually mapped the publicly available data sources about justice in Canada. A PhD student canvassed websites and annual reports and other sources of institutional data, and he looked for who's sharing client numbers, time to trial, court resolution statistics, types of cases, number of users, demand for police services, user satisfaction data, funding levels, areas of request for new legal services. And we looked at this by geography, by province or territory. And we also looked at it by type of organization or institution. You know, courts across the country, are we sharing the same kind of data? Governments, legal aid plans, plea organizations, who's collecting what data, who's making it publicly available. I have a couple of high-level conclusions about this that I think will be no surprise. Not everyone shares the same thing, and not everyone counts in the exact same way. And that's where I think we really see the need to take the kinds of examples we're talking about here today, where we're getting a really nuanced picture of what a particular geography defined or thematically defined audience tells us about their legal needs, and spread that out to learn from that across the country, or to draw conclusions where we are connecting the data because we've actually thought about how to count in a similar way or how to share. If you take nothing else away from my presentation, it would be this one conclusion. I think the primary shift we need to make as a sector is to move away from treating data of all sorts as a way to monitor institutional performance or accountability, and move it to the other end of the spectrum to say, how do we start with data to learn about how to meet needs? How do we stop treating this as something we release after the fact and instead try to bring it back up to the front end, to the design process? And that means no longer thinking about data, even the data we get from our users or our clients or the people who are asking for our services, in terms of our own goals and mandates, and instead starting to look at it as more of a collective understanding of people's legal needs. Not only what we're hearing about today in terms of people's specific experiences of a legal problem, but also complementary data about which services exist, how they work, what's missing, what about all the questions that no one framed as a legal problem. And I've already seen some of the potential connections that people are making in this session. What if we took a broader definition of family law? What if we linked with other aspects of people's legal problems? The potential of starting to share and think about data in that broad way is, I think, where there's a real potential to move data from being not only system-centered, but maybe institutionally driven into being something that's a living, kind of evolving, ongoing way in which we all are rooting our understanding of legal needs. Now, throughout this talk this afternoon, I'm referring to legal services, and I want to use that term very broadly. Any service that is helping people navigate the legal dimensions of their lives. Lawyers' services, legal apps, courts and tribunals, all of those are legal services. So are preventative education programs, programs that intersect with healthcare and social services. And for the next 10 minutes at least, let's think really broadly about legal services as any of the services that support people as they deal with legal issues in a truly people-centered way, not a system-centered way, in order to think about where we might find those connections between data and find ways to use the kind of data being generated by the 4 examples we just heard from to inform rethinking of the kinds of services or the kind of way we situate legal problems in society. The project we did around data mapping revealed some of these gaps. And, just as an aside, the spreadsheets that mapping process produced are being shared this week as part of Access to Justice Week with the provincial territorial collaboratives like the A2J committee here in Manitoba, as well as with those institutional national bodies, so that the Association of Legal Aid Plans can take a look at what are they each sharing? Why are some sharing more than others? Maybe there's a way they could learn from each other's data collection. And we're hoping as a result to not only invite people to correct us by adding more publicly available data sources, to maybe compare their data transparency approaches with other jurisdictions and find models for more sharing and coordination, to realize that in fact, some of the data that they haven't been sharing publicly will be shared in that way publicly. So turning from that, I think a little bit to more of what is possible, I want to challenge you to think about all of our conversations about data in terms of, what would be possible if we had a robust culture of data collection and of data sharing? And what if we stopped treating data evaluation and accountability as an accountability tool and started working with it to really understand what people need? Now, I'm going to give you a few examples, but I know these are just my ideas and what I see from the context I'm exposed to, but the real scope of what we could do is so much broader and more excited than just my imagination. The other panelists here also have all of these great ideas about where this data could lead us. What if we looked at other sectors and we could see how they use data to shape all kinds of things? What time of day people like to shop online or read the news or open Twitter gets used to dictate how Netflix programs its algorithm, how government information websites are designed, how hospital triage systems work, what pharmaceutical marketing looks like. And in the justice sector, we've often really taken user data simply to the stage of saying, okay, now what does that mean for my existing service? Rather than that big rethink, that big disruption that we're seeing in other sectors. We haven't really been looking at the data we have about a justice system to take us to those really big questions of redesign or to fully center how people understand their legal issues. If we had a robust data culture, we might track and share the kinds of questions people ask when they come into a library or a law firm or a phone line, and connect all of those together so that we could track the topic, the time of day that they search, what they know, what they don't know when they ask. Sharing that across institutions might help us change the kinds of preventative services we offer, reposition where private legal services are available or what they focus on, change the kinds of services that are available at the registry or the courthouse. And that's not going to come just because we understand the upfront legal needs and our own evaluative data. It's going to be because we start to make those connections in between. I think the same is true when we talk about money questions. How much are people spending on their legal problems? Not just on lawyers' fees, but on how they deal with the anxiety it causes them. What are their healthcare costs, the lost work, the erosion of trust in their families? What are the concrete costs of the legal process? How much time is lost because we need to do things in person between 9 and 5 in terms of lost wages, childcare, transportation costs? How do we start to think about the whole spectrum of data around a person's experience of a legal problem? And this, I think, is sort of the next step after we get to that legal needs assessment, to say, let's start learning now from other aspects of a legal experience to really bring a people-centered approach. That takes me to the second project of the Action Committee, and I'm just going to mention it briefly. It was completed this summer, and that was to dig into the public data set that Susan mentioned earlier. The data set is available for use for researchers and statisticians, and I think you've heard some great examples today of researchers who are taking that and doing something really important with it. But let's be honest, for many of us working on access to justice, we don't have the level of expertise and comfort with data that an academic does, that someone who's familiar with statistical software does. And so the first thing that the Action Committee did was to take some of that publicly available data set and translate those coded data sets into English so that a person like me could understand it. And I also want to be clear, I didn't do that. We hired a brilliant law student who has a background in data analysis, Simran Hanjan, who did that for us. And she pulled out some of that data and made it easier to start working with. We started running different comparisons. What are the differences in serious legal problems that people face by region, by demographics, young people facing more discrimination, more consumer debt issues. And now how do we take that and combine it with what we know about access to justice that's happening across Canada? How do we have the access to justice committees, like the one that's convened this session, talking to the others in other jurisdictions about what that data snapshot shows them in terms of which projects should be prioritized? Do we have an opportunity to learn from each other? So as an example, we looked at things like problems with major purchases, and that was ranked very highly in Quebec, and it didn't even make the top 5 in another province. Does that tell us something interesting about whether there's a difference in the law in Quebec that gave different consumer rights? Maybe in another location, the public legal education is more focused on consumer issues or less. Can we see whether there's a promising practice somewhere happening across the country that the differences in this data point to that help us actually understand how to shift what we're doing now? And I would argue that this kind of process needs to happen simultaneously to the kinds of rigorous analysis that digging right into Manitoba's experience around civil legal needs happens. So we're moving both deeper within a jurisdictional context and broadly across the country. As a new lawyer, this kind of comparison data might help inform how we specialize, what areas to pursue extra training. It might help a judge to take a look at trends in court scheduling or judicial training. It might let us learn from other jurisdictions about their resolution rates. What does it tell us about where the gaps in legal services are across the country, to make sure that when we find something that works, it is actually being shared and we aren't keeping those kinds of innovations just to one community and instead are amplifying those in ways. Now at the Action Committee, we don't propose to have answers to all of these questions. The Action Committee isn't the body to do this analysis. You've heard, in fact, from many of the organizations today, and I suspect many of you here today are from those organizations who could pick up a small piece of this data and run with it. What the Action Committee wants to do is promote the shift in thinking about data as an accountability measure to move it up much earlier in the process as a tool for designing legal services and shaping the future of law. And I think this goes to questions about how do small organizations participate in this process to align their data collection with the frameworks being used by big institutions. We can't wait until there's sort of a full published report to think about how those small organizations actually already have a small snapshot of the picture that we need, and we need to figure out how to line those up so that the data can speak to each other. But first, of course, we need to both collect and then share that data. And that means we need to stop being afraid of the scrutiny that data will attract and start instead seeing the potential to be truly people-centered at an organizational level and at an individual level. I think it also means we all need to start engaging with data, not just the expert academics and researchers. And you've heard from some today that I admire greatly. And as I listen to them, I think I wish I knew how to get into it at that level. But I also think we need people at my level to understand and feel comfortable talking about data, asking questions, sharing it, working with practitioners, working in multidisciplinary teams so that we bring data to the forefront and are able to make evidence-based decisions. What are those next steps? How do we do that? We need to scale our perspective. Instead of thinking just about our clients as users, let's start thinking about those who have never accessed legal supports, who never answer the survey because they think they've never had a legal problem. But in fact, talking to them, we realize that they've been fired, that they've been evicted, that they faced all kinds of issues that in fact have a very clear legal dimension. What about those who are afraid to participate and talk and participate in these conversations? What about those who've had experiences historically with the way the legal system as a colonial system or the way data usage also linked into legal regimes and access to services has been used to harm their communities? How do we broaden our perspective a bit when we talk about data? I think it's tempting now that we finally have some data as a result of some of the projects we've heard today to just focus on that. And we need to continue to keep asking, what about the people left out even of this data? Though I don't want to emphasize how great it is to have this data. How do we start thinking about the way we will look at data from that fully people-centered view, not just from how it answers the question we already knew we were asking, but what does it tell us about some questions that we should have been asking and haven't been so far? And then I think finally, we need to look at what's happening internationally. How is our data just a small part of a bigger picture? How do we continue to think about that and share on a larger scale? Within that in mind, I'm going to highlight just a couple of things that are happening through the Action Committee. And I just shared some slides here with you around the Action Committee itself. The Action Committee encourages sort of more alignment of access to justice activities and reporting to get a better sense of what's happening across the country. And in sharing this, essentially, I'm sharing an invitation. The Action Committee adopted Canada's Justice Development Goals. And this is a framework for, like the Sustainable Development Goals, if you're familiar with the UN's work, it's a framework for looking at some goals that we can all align our work together with, that we all have some part to play in advancing, recognizing that no single body is going to fix access to justice, no single entity is in charge, and that the more we see how our work helps to promote these 9 justice development goals, we have a way to align that work moving forward. As we get more data, more of a picture of what's happening, we might be able to say eventually that access to justice has increased by 2% in a given year, or that seniors' access decreased last year. We won't really know until we start sharing that data in a coordinated way. And so that's some of what's happening with the Justice Development Goals. In 2021, we collected data from organizations across the country about what they were doing on access to justice. And those are available on the Justice Development Goals website with images like the one you can see here. Every one of those little bright colored pies, you can hover over and it will tell you about a project that's happening in that province is advancing one of the Justice Development Goals. Looking at the goals themselves, there's room to see a little bit more detail about what's happening to advance that particular goal. So these are screenshots of 2 of the Justice Development Goals, where each of the circles or squares represent a project that is particularly responding to, in the first one, Goal 1, address everyday legal needs, and in the one that's in orange behind that, improving family justice. So these are just some of the ways that I think we can start to think about how to share data to move us towards this international or this national snapshot. And that lets us start to speak in the international context. You can see here on the slide, the World Justice Project, which conducts an annual Rule of Law and Access to Justice Index. It measures levels of access to justice in countries around the world. And each country gets measured every other year. And then it generates a comparable index that lets us see where we sit compared to other countries and how to learn from practices in other countries. It has a number of 8 different factors that it uses, and civil justice is one of them. And so here on the screen, we can see just the indicators that are measured for the civil justice context. And this reveals, I think, to us how far behind we are in generating and sharing data and transforming legal services, because this World Justice Project is actually giving us a really useful snapshot nationally that we haven't always had around not just the civil legal needs that we're hearing about today, but how to make connections between that and being free of corruption, of working in environments with unreasonable delay. How do we talk about delay in the civil justice system and link it into access to civil justice? And so this index and some of the work that's happening internationally is out there with a really comprehensive approach to how to start thinking about data to inform our practices and make those connections. And in Canada, I would say we are just on the cusp of figuring out how to do that sharing so that we can engage in this in a strategic way. I find this project of, the prospect of shifting into a data-informed approach of system transformation really exciting. We no longer need to focus on what changes to a system make it easy to be a lawyer or a judge or a clerk working in the system, but instead, how do we make it easier to be a litigant? Or to use even more people-centered language, how do we make it easier to be a person with a legal problem at whatever stage you are in the process? And starting there, start to think about what that means for justice system reform. I think, frankly, it's also going to make it easier to be a lawyer or a judge or a clerk working in the system, as we've seen in healthcare and other contexts, where that people-centered lens has really improved the experience for everyone. I will leave it there and look forward to some discussion with the panelists, and I will share the links to the website. I've shared the link to the website in the chat, and I would love to engage with anyone who is interested in moving forward in this area.
Thanks so much, Sarah. And so now we've got time. Thank you to all our panelists. And now we've got some time for some questions and answers, just in terms of the questions that have already been received and a bit of a kind of heads up to the presenters and how I'm going to approach this. There's a really important question about data governance from an Indigenous communities and Black communities perspective in OCAP and EGAP. So I think we'll get to that first. And then from there was some specific questions about the Manitoba surveys to Gerard and Amy, and some specific questions to Susan's work in particular around the Access to Justice Index. I'll continue to monitor the Q&A section, but we'll start there. And so the first question, which I think I'll go to you, Sarah, to start us off, and others are welcome to chime in. That first question was really just about data governance for Indigenous communities and OCAP principles, and for First Nations, and EGAP for Black communities. And so for those participants who might not be familiar with that, we're talking about OCAP being ownership, control, access, and possession when it comes to First Nations data, and EGAP being engagement, governance, access, and protection. So Sarah, do you have any comments about that to start us off?
You know, I think those are two models for how to approach data collection that are responsive to those kinds of examples that I mentioned earlier, where there are communities with a history of the way data is used to do harm, or data inadvertently has done harm. You know, whether it's coming from a commitment to being people-centered, or it's coming from a commitment to be humble and respectful about relationships with community in line with an ethics protocol, or in line with a commitment to reconciliation. In all of these contexts, I don't think it's actually that much of a stretch for us to say our starting point isn't as experts controlling the data. Our starting point is to think about the people whose experience we're talking about as experts as well. Listen to them about the protocols that are meaningful in those communities, and be ready to learn from and accept those challenges to the sufficiency of data or the approach to data collection. Maybe even be asking those questions before we start, rather than waiting until someone is putting out that challenge. Because I think a commitment to data collection, whether within the confines of the ethical parameters of academic data, or at the level in which a small nonprofit wants to survey its users, needs to recognize always that data is powerful in making change. It's also powerful in doing harm. And we need to be really conscious of that at every step. This isn't just a question sort of formally to be dealt with in an ethics process. It's also a question that matters when you're doing this on a smaller scale.
I can just add a couple of comments.
Thanks, Susan.
Thank you, because I agree, Allison, to start with this question, which is a really, really important one. Some of our work, so for example, the Canadian Legal Problems Survey, we're working directly, so we've commissioned Statistics Canada to undertake that, and they work under the auspices of the Statistics Act, which is federal legislation. They are very definitely, now I don't work for Statistics Canada, so I can't speak on their behalf, but they're very, very conscious of OCAP and as well, AGAP, excuse me, and do work with Indigenous organizations. And they have quite a bit of actual special programming that works. I think one of the examples that I look to in terms of where we may be going in the future, I don't think we're there yet by any means, but I was working with the Public Health Agency on the Canadian Incident Survey, which is all around, pulls administrative data on number of reported incidents of child abuse and maltreatment, to child protection agencies, and it had not been undertaken sort of across the country since 2008. Public Health Agency was working with a group of academics and experts to resolve some methodological issues, and then it was going to contract back out the actual undertaking of the research originally in 2008, and the previous cycle had been done out of McGill University. And when they considered the OCAP principles with that, they actually ended up contracting with the Assembly of First Nations. So there's a core survey, and then there's an additional piece that is specifically for Indigenous children and their families, so sort of looking at those reports and follow-up investigations. And so with the AFM, they had the contract to do the entire body of work, subcontracted out the actual sort of general population work, and kept the work looking at First Nations, Métis, and Inuit children. So sort of the reversal of what we might see today, where you might have the work being done kind of for everyone by, for example, an institution. And in practical terms, it was a contracting nightmare, I understand, but it actually really held up under the principles of OCAP, which I think we're still really working through those at a government level. I think that's sort of about what I can say. Really important. Our entire group will be taking training on that early in the new year. So we recognize how important it is, and I just think that there's more work to be done.
I might just add one thing.
Amy, go ahead.
Yeah, just to kind of broaden the question a little bit too, because OCAP in particular really focuses on data collection and how data is then stored and used. But also I think what is important and is being recognized more and more is the need to involve Indigenous communities, as well as an Indigenous representative and representatives of Indigenous communities, as well as, people of color. If you're collecting data around particular indicators, they really need to be involved in the process of defining those indicators, because it's not just what you do with the data once you collect it. It actually needs to be relevant data and reflect their experience. And if you're not having that conversation at the design phase, you're not actually going to be collecting the right data for some of those groups.
Thanks, Amy, for that. That's very helpful. I'm just going to go to the questions that came in about the specific Manitoba surveys. So Gerard, there was a question about whether or not your survey included questions about law and procedural reforms that might be needed. And then there was also a question about where folks might find like where the reports will be published and where they'll be posted. I think that question also relates, Amy, to the survey you're involved in. So we'll then jump to you for that information. Gerard?
Did the survey include questions about law and procedural reform needs? No, a little insofar as it was procedural reform was identified as a potential access to justice impediment that parties, respondents could cite. It was not the focus of the survey. Potentially in the future, I'm very open-minded to looking at that because I have significant background in procedural reform and surveying lawyers about it, but it wasn't at the core of the survey. When will the results be published? I'm hopeful by the end of the year. I'm going on parental leave in January and therefore want to get it done before then. I don't want to promise anything, but hopefully it will be published in a form, still not probably a final form, by the end of the year or very early January.
Thanks, Gerard. And the publication details for your work, Amy?
Yeah, it will eventually, probably next year, 2023, in the early part of the year. It will be published on the Manitoba Law Foundation's website. So that is Manitoba Law Foundation, all one word, .org. So it will be found there. And that's also where the literature review is currently residing, that I mentioned in my presentation as well.
Thanks, Amy. There was another series of questions specific to Susan's research, and I think they were all related to the A2J index. So Susan, the A2J index, there was a question about whether there was any potential for a similar type of index, recognizing that it's geared to administrative tribunals, whether there was a similar type of index that could be available for organizations that actually provide those legal services and representation, to provide data at that kind of ground level, and some questions around the success of non-governmental organizations participating in the index. So maybe we'll start there, and then there's a couple other questions about the index that I'll pose to you.
Yeah, it's a really great question. So the index, the method we used was actually, as I mentioned, developed from an index that was developed for civil courts in all 50 states. And we took it and applied it to tribunals. We envisioned actually working with groups of tribunals. So for example, human rights complaints mechanisms, tribunals, commissions, or labor boards, for example, to develop sort of a tool that could be used for them where you would have consistency and the questions would be really much more specific. Right now, it's fairly generic. In terms of using them with organizations, you could think of like a legal clinic or other community service. And I think I would say the potential is endless. And what we tried to do in the department, I say try because we sort of did a pilot about 4 years ago. So 2018, maybe the summer of 2019, was we actually adapted the index to look at access to justice as well as well-being. You may remember I mentioned in my comments that at least 7 of the funding programs have those outcomes as sort of the long-term outcomes for the objectives of the programs. And so what we did was we actually asked organizations, and they were both NGOs as well as sort of government, provincial and territorial government programs, to respond to this questionnaire. And it was a much shortened questionnaire, and it had some wellness questions in there from the well-being index that was developed out of the University of Guelph, which Sarah knows well because we had presentations on that as well. And so it was funding recipients really. And I think that ties into one of the other questions as well. And it worked sort of, but not perfectly. I think more work needed to be done to adapt it, but also we needed to get the actual program at the right point so that we had some programs that were still in the process of setting up. We had some that had only been underway for 6 months, and so really couldn't even answer all the questions just because they hadn't seen enough clients at that time. But I think it's a really kind of exciting idea to apply this lens of access to justice that's very people focused to an array of different services.
Thanks, Susan. That's really helpful. The one other comment about that index was a question about why there wasn't a specific statistic around experiencing a family breakdown. And I wondered if you had any comments on that, or if it was reflected.
Yeah, I wasn't sure maybe if that was about the index or if that was about the Canadian Legal Problems
It was
survey.
probably, sorry, my mistake.
So I can provide, yeah, so we only listed sort of the top number. And I've had a couple questions about that, about where's family? And I said, well, it didn't just, it didn't show up in those top, but what we have done, and we'll have fact sheets coming out hopefully before the end of the year on what responses say about people who've experienced family disputes. And what we ended up doing was we combined family breakdown, which was one category, issues around children, so custody, access. I'm using the old terminology because that was the terminology in place when the survey went out. And then the third category, which people don't necessarily think of family, but it was really about taking care of someone else. So it could be powers of attorney, wills, sort of estate planning, that type of where you're helping out, often in a family context, but not exclusively. And for those, so if you'll remember the Canadian Legal Problems Survey, 18% said they had a serious problem, difficult, and it was difficult to solve. So they could have had mentioned a family problem, a serious family problem, but then didn't go on to find it difficult to resolve. For example, divorce doesn't have to be, although they often can be, difficult to resolve. It could be a amicable sort of parting of ways. But out of those who sort of fell into that 18%, almost 10%, 9.7% of people said that it was a family breakdown issue. And children's issues were 6%. And then the taking care of someone else was 8.7%. So sort of just under 10%. So they were definitely up there, much higher than a number of the other different problem categories, but not kind of in those top 5. I don't know if that additional detail is helps.
Thanks, Susan. And so there's another question come in around access to justice, specifically around family law and funding to legal aid. I will note that, Gerard, you did speak to funding of legal aid throughout your presentation of your preliminary results. So I'll maybe suggest to the questioner that they revisit your presentation in the recording. But I know that Sarah is prepared to take on an answer to that question. So Sarah, if you could help us out.
I think it's a really interesting question, specifically around what you're asking about what does this mean and how do we do something about legal aid? But also, I think a question a lot of people hear when we look at this data to say, what does this mean? How do we make this better understanding of people's needs relate to concrete system reforms in the system that we're working in? And you know, the funding of legal aid is a good example where we have often, as a system, faced a lack of political interest by the electorate or by cabinet in whichever jurisdiction we're in to fund legal aid. And if we can't make the case for how increased legal aid funding is going to address the real needs that people face with the concrete impacts on their life, their well-being, their healthcare, all those kinds of things, we have not been winning that argument at the cabinet table or at the election ballot box. Getting this data isn't going to automatically trigger increased legal aid rates, or maybe it will, but I'm doubtful it's going to automatically lead to that. I think it's going to be that it's going to give us new tools. And some of those tools are going to be the tools that governments and legal aid plans use to better resource the highest need areas of funding, for example. Some of it is going to be a tool that you know, the general public or the legal profession use to demonstrate how our idea of legal aid funding and needs is outdated and make the case for making that shift. And to do that, we're going to have to first get the data, know how to share it and talk about it, and then let different people develop those strategies. That a law society might be a great advocate around the interests of changing legal aid funding in a way that judiciary isn't. And we know that that's the reality. And this data, I think, is such a key component to how we start to push decision makers to use this evidence and to base their decisions on evidence and to be accountable when they don't. And up till now, with the gulf of data like this, we haven't had a good argument to come back at that point. We haven't had a way to really make the case. I think that that's a critical process. We're not going to get legal aid data by just saying, trust us, we need more. And we've tried that and it hasn't worked collectively. Maybe it's worked better in some provinces than others, but really this is around finding the way to make those connections so that we can make the case for the wide variety of needs we know are there in the system and ones we're learning about as we go.
Thanks, Sarah. That's really helpful. And I think that's we're coming to the close of our time, and I know this is one of the lengthier CPDs, so I'm really appreciative of everyone's time and energies today, and there's been lots of fruit for discussion. And I think just understanding the kind of efforts that are being made currently around addressing some of those gaps in data that have existed certainly in Manitoba for so long, and just also imagining what can be done with it is a really great place to end on. And so thank you all for your participation. And just a reminder that the slide decks that were shared throughout the presentation will be shared in the email following, but the specific slides around preliminary data will be held back because of the preliminary nature and the unreleased nature of that data. So broadly speaking, the slide decks will be made available to folks who were asking about that. And there may be some opportunities hearing around the timing of the release of that, that you should be having access to that data in a more formal way in the coming months. So again, thank you everyone for your participation, and make sure that if you haven't already had the opportunity that you check out the other Access to Justice events that are being held throughout the week across the country. There's a lot of really interesting conversations that are taking place. So thanks everyone.
Thanks. Thanks everyone for joining.
Thank you all.
Thank you.